Hi, welcome back to my channel. So for today's video, we're going to talk about the Doctrine of Proximate Cause. So this video is basically relevant for my video about Article 4 of the Revised Penal Code, which is criminal liability. So without further ado, let's start our discussion. So what is proximate cause? So basically, proximate cause is that cause which in its natural and continuous sequence, unbroken by an efficient intervening cause, produces the injury without which the result would not have occurred. It refers to the responsible cause. So a proximate cause does not necessarily imply, as might be inferred from the word itself, the nearest in point of time or relation, but rather the efficient cause, which may be the most remote of the operative chain. It must be that which sets the others in motion and is to be distinguished from a mere condition upon which the effective cause operates and must have been adequate to produce the reluctant damage without the intervention of the dependent cause. So under paragraph 1 of Article 4, the initial act of the perpetrator must be for the purpose of committing a felony, in order for him to be liable for all the direct, logical, and natural consequences of his action. Thus, if he was committing an act which would be a felony and in the process had committed another crime which is different from that which he originally intended, the person is still criminally liable from the resulting felony. This is the basis of the concept of proximate cause. This is also based on the Latin maxim il quo es causa de la cosa es causa del mal causado. So let's have an illustration for that. So Juan, without any intent to kill, backs Pedro without any reason at all but to show that he is somebody. Pedro fell down and struck his head on the pavement, causing intracranial hemorrhage, which resulted to Pedro's death. Is Juan liable for the death of Pedro, even if he has no intention to kill the latter? The answer is yes. Juan is liable for Pedro's death, although he has no intention to kill Pedro. He committed the crime of homicide and not merely physical injuries because his initial act of boxing Pedro was a felony, and he should therefore answer the direct, natural, and logical consequence of his act of boxing Pedro. So what about the fact that he has no intention to kill Pedro? It will be treated only as a mitigating circumstance for having no intent to commit so grave a wrong as that committed. So, if the intervening cause, however, is efficient such that it constitutes as the very cause of the proximate cause of the injury, the accused will not be liable thereto. So as we have illustrated on our example, so a person committing a felony is criminally liable for all the natural and logical consequences resulting therefrom, although the wrongful act done be different from that which he intended. So what is natural? So natural refers to an occurrence in an ordinary course of human life or events, while logical means that there is a rational connection between the act of the accused and the resulting injury or damage. So the felony committed must be the proximate cause of the resulting injury. Proximate cause is that cause which in natural and continuous sequence, unbroken by an efficient intervening cause, produces the injury, and without which the result would not have occurred. So the proximate legal cause is that the acting first and producing the injury, either immediately or by setting other events in motion, all, all constituting a natural and continuous chain of events, each having a close causal connection with its immediate predecessor. So there must be a relation of cause and effect. So the cause being the felonious act of the offended, then the effect being the resultant injuries and or death of the victim. So the cause and effect relationship is not altered or changed because of the pre-existing conditions such as the pathological condition of the victim or the las condiciones patológicas del lesionado, or the predisposition of the offended party or the la constitution física del heredo, or the concomitant or concurrent conditions such as the negligence or fault of the doctors or the la falta de médicos para asistir el heredo, or the conditions supervening the felonious act such as tetanus, pulmonary infection, or gangrene. Gangrene? So the felony committed is not the proximate cause of the resulting injury when, number one, when there is an active force that intervened between the felony committed and the resulting injury, and the active force is a distinct act or fact absolutely foreign from the felonious act of the accused, or number two, the resulting injury is due to the intentional act of the victim. So if a person inflicts a wound with a deadly weapon in such a manner as to put life in jeopardy and death follows as a consequence of their felonious act, it does not alter its nature or diminish its criminality to prove that other causes cooperated in producing the factual result. So the offender is criminally liable for the death of the victim if his delictual act caused, accelerated, or contributed to the death of the victim. So a different doctrine would tend to give immunity to crime and take away from human life of salutary and essential safeguard. So the following are not efficient intervening causes. So number one, the weak or diseased physical condition of the victim, as when one is suffering from tuberculosis or heart disease, cited in the case of People versus Illustre and People versus Reyes supra. Number two is the nervousness or temperament of the victim, as when a person dies in consequence of an internal hemorrhage brought on by moving about against the doctor's order because of his nervous condition due to the wound inflicted by the accused. Cited the case of People versus Amonte 56 Phil 54 and People versus Quinto 62 Phil 162. Number three Number three is the causes which are inherent in the victim, such as number one, the victim not knowing how to swim, and number two, the victim being addicted to tobacco drinking. Cited the case of People versus Buhay and U.S. versus Valdez supra, U.S. versus Bayutas supra. And number four neglect of the victim or third person, such as the refusal by the injured party of medical attendance or surgical operation, of the failure of the doctor to give anti-tetanus injection to the injured person. Cited the case of U.S. versus Marasigan and People versus Red Supra. And number 5, erroneous or unskillful medical or surgical treatment, as when the assault took place in an outlying barrio where proper modern surgical service was not available. Cited the case of People versus Valdez, 61 Phil 1. And the last one is number 6, delay in the medical treatment of the victim. Cited the case of People versus Akoram, GR number 117954, April 27, 2000. So those causes are not being efficient intervening causes, do not break the relation of cause and effect, the felony committed, and the resulting injury. So you can also see or use the case of People versus Piamonte et al., 94 Phil 293, and the case of People versus Garcia, GR number 171951 2009, for proximate cause. So now let's go to when death is presumed to be the natural consequence of physical injuries inflicted. So the death of the victim is presumed to be natural consequence of the physical injuries inflicted when the following facts are established. So number 1, that the victim at the time of physical injuries were inflicted was in normal health. Number 2, that may be expected from the physical injuries inflicted. And number 3, that ensued within a rational time, cited in the case of People versus Dato Baginda, CA 44OG2287. So let us take the case of People versus Tamang 5CA Rep 145 also as an example. So it having been established that the boy Jundam was in good health on the morning of the incident, that he was whipped, spanked, and thrown against the post by his teacher, his breast hitting it, that he complained to his mother about the oppressive pain, crying and massaging his breast all the time, that he was found to have 2 suspicious bluish spots, a big one on the breast and the other one on the upper left arm, and that he vomited blood until he died 3 days afterwards, and there being no proof of any intervening cause. So the liability of the teacher for homicide necessarily follows from the premises stated. So note that had it been proved as claimed by the defense that the boy died of hydrophobia, that would have constituted an intervening cause and the accused would have been acquitted. Now let's go to the not direct, natural, and logical consequence of the felony committed. So if the consequences produced have resulted from a distinct act or fact absolutely foreign from the criminal act, the offender is not responsible for such consequences. So a person is not liable criminally for all possible consequences which may immediately follow his felonious acts, but only for such as are proximate. Okay? So thus, where a person struck another with his fist and knocked him down, and a horse near them jumped upon him and killed him, the assailant was not responsible for the death of that person. This is cited in the case of People versus Rockwell, 39 Mich 503. This case should be distinguished from the case of People versus Kagoko 58 Phil 524 Supra. So in the Kagoko case, there was no active force that intervened between the felonious act and the result. While in the Rockwell case, there was an active force, which is the jumping of the horse upon the deceased, which produced the result. So in the following cases, the injury caused is not the direct, logical, and necessary consequence of the felony committed because the felony committed is not the proximate cause of the resulting injury. So, number one, if slight physical injury be inflicted by A upon B and the latter deliberately immerse his body in a contaminated cesspool, thereby causing his injuries to become infected and serious, A cannot be held liable for the crime of serious physical injury. This is cited in the case of U.S. versus De Los Santos, GR number 13309. So the act of B in deliberately immersing his body in a contaminated cesspool, not the slight physical injuries inflicted by A, is the proximate cause of the serious physical injuries. Number two, so the accused struck a boy on the mouth with the back of his hand. Later, the boy died. That might have been caused by fever prevalent in the locality but not by the blow on the mouth. The accused who gave the blow was not liable for the death of the deceased. This is cited on the case of People versus Palalon 49 Phil 177. Number 3. That the accused struck a child who was seriously ill with fever for 3 weeks upon the thigh with a slipper, pushed and dragged him, throwing him heavily on the mat spread on the floor. The child died 2 days later. As the true cause of the child's death was not proved, the accused was convicted of physical injuries only, cited in the case of U.S. versus Imbate 3 Phil 640. And number 4, where medical findings lead to a distinct possibility that the infection of the wound by tetanus was an efficient intervening cause, later or between the time the deceased was wounded to the time of his death, the accused must be acquitted of the crime of homicide, cited in the case of Urbano versus IAC 157 Escra 10. Now let's go to the felony committed is not the approximate cause of the resulting injury when, number 1, there is an active force that intervened between the felony committed and the resulting injury of the active force is a distinct act or fact absolutely foreign from a felonious act of the accused, or the resulting injury is due to the intentional act of the victim. So is the accused responsible for the result if there is a neglect of the wound or there is an improper treatment of the wound? In the case of People of the Philippine Islands versus Valdez, GR number L 4212-1934, where the accused was convicted of homicide, counsel for the accused claimed that if the deceased had secured proper surgical treatment, the wound would not have been fatal. The court held that the general rule is that he who inflicts the injury is not relieved of responsibility if the wound inflicted is dangerous, that is, calculated to destroy or endanger life. even though the immediate cause of the death was erroneous or unskillful medical or surgical treatment. So unskillful and improper treatment may be an active force, but it is not a distinct act or fact absolutely foreign from the criminal act. So is the accused criminally liable for the consequences which originate through the fault or carelessness of the injured person? So in the case of U.S. versus Monasterial 14 Field 391, it was held that persons who are responsible for an act constituting a crime are also liable for all the consequences arising therefrom and inherent therein, other than those due to incidents entirely foreign to the act executed or which originate through the fault or carelessness of the injured person, which are exceptions to the rule not arising in the present case. So in the case of People versus Quinto, 62 Phil 162, it is stated that one who inflicts injury on another is deemed guilty of homicide if the injury contributes to the death of the latter, even if the deceased might have recovered if he had taken proper care of himself or submitted to surgical operation. It would seem that the fault or carelessness of the injured party which would break the relation of the felony committed and the resulting injury must have its origin from his malicious act or omission cited in the case of U.S. versus Navarro 7 Field 713. So as when the injured party had a desire to increase the criminal liability of his assailant. So now let's proceed on the topic about a supervening event may be the subject of amendment of original information or of a new charge without double jeopardy. So where the charge contained in the original information was for slight physical injuries, because at the time the fiscal believed that the wound suffered by the offended party would require medical attendance for a period of only 8 days, but when the preliminary investigation was conducted, the justice of the peace found that the wound would heal after a period of 30 days. The act which converted the crime into a more serious one had supervened after the filing of the original information, and this supervening event can still be the subject of amendment or a new charge without necessarily placing the accused in double jeopardy. This is cited in the case of People versus Pitela, 92 Field 395. Now let's go to how to determine the proximate cause. So, at about 2 in the morning, while the bus was running very fast on a highway, one of the front tires burst and the vehicle began to zigzag until it fell into a canal and turned turtle. Four of its passengers could not get out of the overturned bus. It appeared that the bus overturned. Gasoline began to leak from the tank on the side of the chassis, spreading over and permeating the body of the bus and the ground under and around it. About 10 men, one of them carrying a lighted torch, approached the overturned bus to help those left therein, and almost immediately a fierce fire started burning the four passengers trapped inside. What is the proximate cause of the death of the four passengers? The negligence of the driver resulting in the fall into the canal and overturning of the bus, or the fire that burned the bus? So it may be the originally when a passenger of bus overturns and pins down a passenger, merely causing him physical injury. If through some event, unexpected and extraordinary, the overturned bus is set on fire, say by lightning, or if some highwayman, after looting the vehicle, set it on fire, the passenger is burned to death. One might still contend that the proximate cause of his death was the fire and not the overturning of the vehicle. But in the present case, and under the circumstances obtaining the same court, the court does not hesitate to hold that the proximate cause of death of the four passengers was the overturning of the bus. This for the reason that when the vehicle turned not only on its side but completely on its back, the leaking of the gasoline from the tank was not unnatural or unexpected. That the coming of the man with a lighted torch was in response to the call for help made not only by the passengers but most probably by the driver and the conductor themselves, and that because it was very dark, about 2:30 in the morning, the rescuers had to carry a light with them, and coming as they did from the rural areas where lanterns and flashlights were not available, they had to use a torch, the most handy and available. And what was more natural than that said rescuers should innocently approach the overturned vehicle to extend the aid and effect the rescue requested from them. In other words, the coming of the man with a torch was to be expected and was a natural sequence of the overturning of the bus, the trapping of some of its passengers, and the call for outside help. What is more, the burning of the bus can also in part be attributed to the negligence of the carrier through its driver and its conductor. According to the witnesses, the driver and the conductor were on the road walking back and forth. They, or at least the driver, should and must have known that in the position in which the overturned bus was, gasoline could and must have leaked from the gasoline tank and soaked the area in and around the bus. This aside from the fact that gasoline were spilled, especially over a large area, can be melted undetected even from a distance, and yet neither the driver nor the conductor would appear to have cautioned or taken steps to warn the rescuers not to bring the lighted torch too near the bus. That is negligence on the part of the agents of the carrier. This is cited on the case of Vida di Bactan et al. Versus Medina, 102 Phil 181, 186, and 187. So the cases mentioned in this video will be written in the description box, and I also make some separate videos of some of the cases I mentioned or I use, which I will also be writing in the description box. So this ends my video. Thank you so much for watching.